All right, welcome to your second set of lecture notes for the topic of criminal law. In today's lectures, we're going to look at the death penalty, we're going to look at Schedule 2 offenses and summary offenses. All right, death penalty. Before, the maximum penalty applied for a criminal offense was the penalty of death, where you be put to death. However, it used to apply to the cases or offenses of willful murder, treason, and piracy. However, there's been a legal amendment when the Minister for Justice was Honorable Brian Kramer, and he basically changed around the penalties. Now, the maximum penalty you can get for willful murder, treason, and piracy is the punishment of life imprisonment. All right, indictable offenses. These are called crimes or misdemeanors, and they may be tried in the national court, and it is declared to be such an offense punishable by imprisonment for more than 12 months. It's what you call an indictable offense. All right, also there are approximately 80 indictable offenses that can be tried summarily by a principal magistrate. So the serious indictable offenses, they're tried by judges in the national court, but 80 of those offenses, they can be tried by the district court. They can be tried summarily in the district court as well. So one classical example would be false pretense, which can be indictable offenses, but it can be tried summarily as well. All right, summary offenses. These are called simple offenses in the criminal code, and basically what happens is that they're tried in the district court. They are punishable by summary conviction. The magistrate has the powers under Section 425 of the Criminal Code to abstain from dealing with certain summary issues, and basically these are called summary offenses. All right, then they also have offenses affecting village life as prescribed in Regulation 3 of the Village Code Regulation and Section 4 of the Village Code Act. These are offenses that may be tried in the village court. Somebody steals your sugar or steals your pig or stuff like that in the village. You can try those offenses in the village court. All right, since we are looking at some offenses in the previous slide, we covered the offense of willful murder, infanticide, and manslaughter. Now we are going to look at another serious offense, which is the offense in your next slides there. I've started off with the offense of rape. If you see the slide, there's a slide that says rape, Section 347 of the Criminal Code, and there's a N print saying stop rape. All right, rape is a very, very heinous crime. It's a crime that can be committed against a male or a female, and as much as possible, it's a degradation of human beings and should never be encouraged, never be thought about, and should never ever, as a normal Papua New Guinean, be sort of aided or abetted, and it should be discouraged in all areas of Papua New Guinea. All right, Section 347 of the Criminal Code defines what is rape. So rape is a person who sexually penetrates. So the important word there, sexually penetrates. Sexual penetration must be active. A person without his or her consent is guilty of the crime of rape. So two important things there. There must be sexual penetration, and there must be an absence of consent. They did not agree to the sexual penetration, and the sexual penetration is okay. That is rape. The offense of rape under Section 347 of the Criminal Code is two elements. The accused, that means the person is accused of a crime, penetrated the person making the complainant, without the complainant's consent. All right, in criminal law, you have to break it down. What do you mean when we say sexually penetrates? All right, sexually penetrates, defined by Section 6 of the same Act. It states that sexual penetration or sexual penetration are used in definition of offense. It's often so far as agreed that the element of it is complaint, where it is the introduction of any extent by a person of his penis into the vagina, anus, or mouth of another person. So anal sex, oral sex, and vaginal sex basically is covered by the word sexually penetrate. or the introduction to any extent by a person of an object or part of his or her body other than the penis into the vagina or anus mouth of another person other than the course of procedure carried in good faith or medical hygiene purposes. So that means that either the use of a person's penis into the vagina, anus, or mouth of another person, or the introduction of any object or part of his body, such as fingers, toes, things like that, into the vagina, anus, or mouth of another person, that will fall within the ambits of what sexually penetrate means. All right, we now go look at what is the definition of consent. Consent is defined by section 347A1 of the Criminal Code. It means free and voluntary agreement. Consent must not be coerced, must not be forced, but there must be free and voluntary consent. All right, consent is not given if violence is used. Consent is not given if intimidation is used. Consent is not given because of fear or harm. Consent is not given because of unlawfully being detained, asleep, unconscious, or affected by alcohol or another drug, incapable of understanding the essential nature of the act or communicating unreasonable pursuit act due to mental or physical disability, mistakenly believe that the act is for medical or hygienic purposes. If sexual penetration happens in those cases and consent happens, consent falls in one of this category, that consent is not true consent, and the person will be liable for the crime of rape. All right. Also, we have what you call marital rape. If entering into a marriage meant that the wife consented to sexual intercourse with the husband. Today, the law is provided for marital rape. A wife has the authority and power to consent to sexual intercourse with the husband. If the husband forces the wife to have sexual intercourse, the husband can be charged for marital rape. All right. In the words of one of PNG's most senior magistrates, Cosmos Bida, in 2019, he said, "There's an offense known as marital rape, which is the act of sexual penetration of one's own spouse without their consent, and it's punishable under the Criminal Code Act." All right, let's look at the example of the case of rape, and we'll conclude this part of the second part of the lectures. All right, so there was a rape case, State Kuman, occurred in Kundiawa along by one coastal Sikman. The victim was walking home from Kundiawa town to go back to the village. The accused and a friend followed from behind caught up with her. The accused gave a shot while their friend twisted legs. They dragged them to the nearby bush. They told her not to scream. Then they pushed her to the ground and stripped off her clothes. The accused forcefully opened her legs, removed his trousers, and inserted his penis into the vagina. The court held that the accused was both found guilty of rape. They sexually penetrated the victim without her consent. They were sentenced to 12 years imprisonment with hard labor, minus the time they spent in pre-trial custody. All right, the next lecture videos, the second lecture videos in the second set of lectures for criminal law, we look at grievous bodily harm and armed robbery and misappropriation, and we'll finish it there. Thank you.